Sometimes clients come to me and they've been stopped after having driven with excess alcohol when they hadn't expected to be driving. An emergency of some sort had arisen. Perhaps a sick child has got to be rushed to hospital or something along these lines. It's not as unusual a circumstance as one might think. The courts will look at what steps you have taken to perhaps try to get other means of transport, a taxi, somebody else, whatever it might be. But where there is a genuine emergency and you act on that genuine emergency, then that is something which is not a defence to a drink driving allegation, but it is something which can be used to argue what's called special reasons. In other words, saying to the court that but for that emergency, you would not have driven the car. In other words, you didn't plan to drive the car. The crucial thing, if one is putting forward this mitigation, trying to avoid a driving ban, is to demonstrate that as soon as the emergency had ended, that one was ceasing to drive. So if, for instance, in the analogy which I've given of taking, say, a sick child to a hospital, if one then drives back after the emergency is over, well, quite clearly, you stand absolutely no chance of succeeding in running such a mitigation. And I stress again, it's not a defence to the allegation. As ever, I would say to you, if you are putting forward an emergency as part of a mitigation, trying to avoid a driving ban, then you'll be wise to speak to a lawyer, barrister or solicitor, perhaps specialising in this sort of work. It's a technical area of law. There is a lot of case law. You'd need somebody who's going to go through that case law and bring the relevant cases to the attention of the court when you're putting forward such a mitigation.